Good evening. I am Robin Wright, Chair of the Contact Committee. It is my pleasure to introduce this evening's speaker, who is one of America's most famous jurists. Clarence Thomas has been an Associate Justice of the Supreme Court of the United States since 1991. Before that, he was a judge on the District of Columbia Circuit Court of Appeals. Justice Thomas was born in rural, racially segregated Penn Point, Georgia. As he recounts in his autobiography, My Grandfather's Son, his disciplined grandparents instilled in him perseverance, respect, and the will to succeed. Justice Thomas excelled academically and graduated from the College of Holy Cross and Yale Law School. His early career included serving as an Assistant Attorney General for the state of Missouri and as an attorney for the Monsanto Chemical Company, and as a legislative assistant to former Missouri Senator John Danforth. Justice Thomas's life is an American success story. His achievements are clearly the product of his hard work, his superior intellect, and his personal integrity. As a Supreme Court justice, Justice Thomas upholds the truth and defends the Constitution and the American values that allow us all the freedom to succeed. He is a strong and independent voice on our highest court. We are honored and privileged to have such a distinguished American as tonight's contact speaker. Before handing the podium over to Justice Thomas, I want to inform you that he has graciously agreed to answer a limited number of questions this evening. Please write your questions on one of the note cards provided and pass the note card to the end of the aisle. Now it is my pleasure to introduce the Honorable Justice Clarence Thomas.
Thank you all. Thank you. Thank you all. Thank you. Thank you all. Thank you all. Ooh. Sometimes I feel like I should quit while I'm ahead. Thank you all. This is one of the first times I've been to an event, and the crowd was here long before starting time. So, what Southern hospitality. I really appreciate it. First of all, thank you all for coming out on such a rainy evening, and it makes it especially delightful for me. I receive quite a few invitations to speak at various events, and I must say I'm not very good at accepting many of those. They gets to be very difficult. Number one, I hate leaving my wife, who's my best friend, and the other thing is that I don't like to give canned remarks to people who come out to hear from you. I try to at least think about it a bit, and that requires time. And sometimes I quite don't have the time. But when I saw Robin Wright's letter, I could not help but recall meeting her as a young girl. I think she was 9 or 10 years old, at a time when I was the circuit justice in the 8th Circuit, where her mother is a federal district judge in Little Rock, Arkansas. And I have, for a decade as a circuit justice, I had an opportunity to spend many hours with her mother discussing our respective jobs and the respective challenges that we faced. I have immense admiration and respect for her mom, and I deeply appreciate her mother's service in what can be a very, very difficult job, a federal district court judge. And I'd also like to thank Robin for her courtesy and the professional and dignified manner in which she handled all of these arrangements, as well as her invitation. During the early and mid-1990s, I made frequent trips here to Lexington while my son was a student at VMI. I loved making those trips, and I have nothing but fond memories of the times that I came to spend at VMI and here in Lexington. I've also visited here at W&L while on the court and while at EEOC, although I did not have nearly this many people show up. In fact, it was as a result of that trip here while I was at EEOC that I thought it would be a good idea for my son to come here to Lexington to attend VMI. It just so happened that my son also met his wife here in church, of all places. So I have used that as an example. Marriages seem to be made in heaven when you meet at church. She has her undergraduate and law degrees from Washington and Lee, and they are a wonderful couple and actually make each other better. When I arrived on the court in 1991, another of your graduates, Justice Lewis Powell, was still at the court. He was a quiet, warm Virginia gentleman. He and I occasionally spent time together over lunch or just chatting during his regular walks through the halls of the court. He liked to refer to us as the southern contingent of the court. Well, the contingent is down to one. One of the things he told me in our meetings, at one of our lunch meetings, was, when you think you belong at the court, it is time for you to leave. And I think he's right. That was a cautionary note from him about the importance of the work of the court and the institution itself in relation to the members of the court. We are less important than the work we do, as well as the institution that we find ourselves a part of. There is some temptation in giving speeches as a member of the Supreme Court, a temptation to disappear behind a veil of platitudes or the miasma of obscure and mind-numbing talk about theory and interpretive methodologies. This is an easy way to impress those who don't quite understand what you are talking about and politely or not so politely mistake it as for something profound. But I think that feigned profundity and convenient obfuscating generalities are a waste of time, yours and mine. Though I hasten to admit that all theory cannot be avoided in any discussion about law, and I must touch on some theory, but ever so briefly and lightly. As I indicated in my memoir, My Grandfather's Son, I was raised by a man who believed in liberty, freedom, and independence. Having come of age in the South in the early 20th century, he clung to the dream of these lifelines to the fullness of humanity and the fullness of citizenship. Among the vast treasures of the legacy that he left my brother and me was his love of freedom, independence, and liberty. Freedom was something that we all dreamed of, to be free of the perils of racial discrimination and segregation, not to mention another menace at that time, communism. Independence, we were instructed, came from assuming responsibility for ourselves and those who depended on the fruits of our labor. Liberty, the forebear of both independence and freedom, was guaranteed by our Constitution, but denied to blacks by those responsible for its interpretation and enforcement. Despite this, there was little doubt in our household that this acorn that lay almost dormant in our Constitution, as informed by the Declaration of Independence, would one day grow into the great oak that our Declaration of Independence promised. This was the promissory note to which Dr. Martin Luther King referred in his I Have a Dream speech during the March on Washington nearly a half-century ago. And I quote, "When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence. They were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. In my youth, this was the promissory note of liberty that we could only imagine would one day be honored. This inspired and informed the dreams that propelled us to hope to be a part of this great country and to live in a way so as to earn the right to the opportunities that were made possible by both those around us and those whose sacrifices and sufferings had long preceded us. When I entered a previously all-white minor seminary in 1964, my grandfather said, "Boy, don't shame me, and don't shame the race." Some today would look at this send-off as an indication that he was too concerned about his reputation or any dishonor that I might cause to be visited upon him. But I know that he couldn't care less what others thought of him, so this inference would be inaccurate. He often said of those who didn't agree with him about one thing or the other, they have a lifetime to get pleased. No, he was saying much more. In his inimical way, he was telling me to bring honor to him, to the nuns and priests who had taught me in the segregated parochial schools, and to all those who had sacrificed to change the society so that I had the chance to cross the color line and to go to the seminary. To bring honor to them, I had to do my best to take advantage of those opportunities, thus giving value and meaning to their sacrifices. In short, I had to earn the right to benefit from their hardships and sacrifices. These days, there appears to be little focus on responsibility, sacrifice, and self-denial. I still recall the many conversations I had during my youth, about deferred gratification, the notion of self-denial for something more important, something larger, or perhaps something transcendent. The notion that life was not about self-gratification, especially at the expense of others, permeated our lives. Those of us who were raised in the pre-Vatican II Catholic Church and attended Catholic schools knew all too well about the push for self-denial, if not self-mortification, especially on meatless Fridays or during a time like this, Lent. We also heard it in the constant warnings and corrections from our parents. Learn to do without. Prepare for a rainy day. No one owes you a living. These themes filled our daily lives and permeated many of our childhood stories. I was in the 9th grade when John F. Kennedy said in his inaugural address in 1963, "Ask not what your country can do for you, but what you can do for your country." We heard his words with ears that had been conditioned to receive this message and hearts that did not resist it. We heard it surrounded by fellow citizens who had known lives of deprivation, sacrifice, and hardship from war, the Great Depression, and segregation. All around us seemed to ingest and echo his sentiment and his words. Our country and our principles were more important than our individual wants and by discharging our responsibilities as citizens, neighbors, and students, we would make our country better. It all made sense. Today, we live in a far different environment. My generation, the self-indulgent me generation of the 1960s, has had a profound effect on much around us. Rarely do we hear a message of sacrifice, unless, of course, it is offered as a justification for more taxation of others and transfers of wealth to others. That is, someone else should sacrifice, but not me. Nor do we hear from leaders or politicians the message that there is something larger and more important than the government providing for all our needs and wants, large and small. The message today seems more like, ask not what you can do for yourselves or your country, but what your country must do for you. This brings to mind the question that seems more explicit in informed discussions about political theory and implicit in shallow political speeches. What exactly is the role of our national government? Or more to the point, what is the role of our government? Interestingly, this is the question that our framers answered more than 200 years ago when they declared our independence and adopted our written Constitution. They established the form of government that they trusted would be best to preserve liberty and allow a free people to prosper. And that it has done for over 2 centuries. Of course, there were major flaws, such as the contradiction of slavery, which would eventually lead to a civil war and casualties of fellow citizens that dwarf those of any war that our country has since been involved in. Though we have amended the Constitution, we have not changed its structure or the core of the document itself. So what has changed? That is the question that I have asked myself and my law clerks countless times during the more than 17 years I've been on the court and almost 2 decades as a federal judge. As I've traveled across this country, I have been astounded just how many of our fellow citizens feel strongly about their constitutional rights, but have no idea what they are, or for that matter, what the Constitution says. I am not suggesting in any way that they become constitutional scholars, whatever that means. I am suggesting, however, that if one feels strongly about his or her rights, it does make sense to know generally what the Constitution says about them. It is at least as easy to understand that great document as it is to understand a cell phone contract. And I might add, it is vastly more important. The Declaration of Independence sets out the basic underlying principle of our Constitution. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. The framers structured the Constitution to assure that the national government be by the consent of the people. To do this, they limited its powers. The national government was to be strong enough to protect us from each other and from foreign enemies, but not so strong as to tyrannize us. Its powers were specifically enumerated, that is, listed. It was divided into 3 co-equal branches, and the powers not given to the national government remained with the states and the people. The relationship between the 2 political branches, the executive and the legislative, was to be somewhat contentious, providing checks and balances, while frequent elections would assure some measure of accountability. And the often divergent interests of the states and the national government provided further protection of liberty behind the shield of federalism. The 3rd branch, and the least dangerous branch, the judiciary, was not similarly constrained or hobbled. Since Marbury versus Madison, the federal judiciary has assumed the role of the interpreter and now final arbiter of our Constitution. But what rules must we as federal judges follow in doing so? What informs, guides, and limits our interpretation of the admittedly broad provisions of the Constitution? And more directly, what restrains us from imposing our personal views and policy preferences on our fellow citizens under the guise of constitutional interpretation? To assure the independence of federal judges, the framers provided us with life tenure and an irreducible salary, though I must admit that inflation has found a way to reduce the irreducible. This independence, in turn, was to assure our neutrality and impartiality, which are at the very core of judging and being a judge. Yet, the same independence can also insulate a judge from accountability for venturing beyond the proper role of a judge. But what exactly is the proper role of a judge? We must understand that before we can praise or criticize a judge. In every endeavor, from economics to games, there is some way to measure performance. As important as our Constitution is, there is no one accepted way of interpreting it. Indeed, for some commentators, it seems that if they like or prefer a particular policy, then it must be constitutional, while the policies that they do not prefer or like have to be unconstitutional. Obviously, this approach cannot be right, but it certainly is at the center of the process of selecting judges. That is, it is outcome-based. It goes something like this. If a judge does not think that abortion is best as a matter of policy, or that is his or her personal opinion, then the thought is that he or she will find it unconstitutional, while the judge who thinks it is a good policy will find it constitutional. Those who think this way often seem to believe that since this is the way that they themselves think, everyone must be doing the same thing. In this sense, legal realism quickly morphs into legal cynicism. Certainly, this is no way to run a railroad, not to mention interpret the Constitution. Judge Robert Bork and his fellow Yale Law School professor, Alexander Bickel, among others, recognized this problem more than 4 decades ago in a 1971 Indiana Law Journal thought piece, as he called it, that would be used to bludgeon him during his failed confirmation process. Judge Bork tried to work through his concerns that the area of constitutional law lacked a coherent theory. Presciently, he went on to say, and I quote, The result, of course, is that courts are without effective criteria, and therefore we have come to expect that the nature of the Constitution will change, often quite dramatically, as the personnel of the Supreme Court changes. In the present state of affairs, that expectation is inevitable, but it is nevertheless deplorable. His point is a simple one. When judges interpret the Constitution, we are treating it as law, much like property law or tax law. None of us, for a moment, would accept the notion that a judge is free to rewrite property law or tax laws to suit his or her preferences. What prevents that? Well, we think he has no authority to change what has been enacted by our political branches, that is, written in our codes of law. And this is the point that Judge Bork makes in his 1990 book, The Tempting of America, the Political Seduction of the Law. And I quote him again, "When we speak of law, we ordinarily refer to a rule that we have no right to change except through prescribed procedures. That statement assumes that the rule has a meaning independent of our own desires." Agreeing with Herbert Wechsler, who had written about the problem of judicial interpretation in the 1950s, that Supreme Court constitutional decisions be based on neutral principles, Judge Bork goes on to observe that no judge will say openly that any particular group or political position is always entitled to win. He will announce a principle that decides the case at hand, and Wechsler had no difficulty with that if the judge is willing to apply the same principle in the next case, even if it means that a group favored in the first decision is disfavored in the second. I note parenthetically that this is an exercise that I engage in with my law clerks when deciding particularly difficult cases. We just simply switch the parties so that to test whether or not we are neutral in the application of a principle. In sports, for example, and there'll be lots of sports this week with March Madness. In sports, for example, we implore the referee who makes calls against our team also to make calls or to call it the same way against the other team. In other words, we are saying at least be neutral or impartial. In the area of constitutional law, I agree with Judge Bork that the judicial philosophy of original understanding or originalism can supply this neutrality and impartiality that proper judging absolutely requires. That is, we must try as best we can to determine the intent of those who drafted our Constitution. To do this, we as judges must accept as law and as given the framers' intentions. We do this with statutes, for example, and contracts. We try to determine the intent of the legislature and, in the case of contracts, the contracting parties. No one would say, for example, "Oh, Judge, we may disagree, but you make up new rules." You simply want us to arbitrate between two competing positions that you think are already in the document. Let me put it this way. There are really only two ways to interpret the Constitution. Try to discern as best we can what the framers intended, or make it up. It's that simple. No matter how ingenious, imaginative, or artfully put, unless interpretive methodologies are tied to the original intent of the framers, they have no more basis in the Constitution than the latest football scores, or for that matter, the brackets for March Madness. To be sure, even the most conscientious effort to adhere to the original intent of the framers of our Constitution is flawed, as are all methodologies and human institutions. But at least originalism has the advantage of being legitimate, and I might add, impartial. It also has the advantage of being something other than the judge's policy preferences. As a judge, the surest way to put a wall between my personal opinions and my policy preferences is to rely on an approach that has firm rules, or, like originalism, has its roots beyond me. The more amorphous or flexible the rule, the more susceptible it is to infection by personal opinions and preferences. Similarly, methodologies that leave both the rule and its application up to judges like me will be laced with personal opinions and policy preferences. Now, having done this job for the better part of 2 decades, I believe the only legitimate way to judge is to do so with the proper respect for the liberties that our framers were trying to protect. To do that, we judges must look to the intent of our framers when interpreting our Constitution, and to that of the political branches when interpreting our laws. One final point on this. Over the years, as I have traveled across this country, I have routinely been amazed at the number of people who seem comfortable with judges making decisions that have the most tenuous of roots in our Constitution. I ask them just what makes them think that granting us judges broad extra-constitutional powers will mean that their policy preferences will also coincide with those of the judges. Of course, they admit, there is no guarantee. I try to point out to them that in accepting the notion that it is legitimate for judges to substitute their values for those already in our Constitution, those applauding this approach are complicit in undermining their own liberties and that of their fellow citizens. Any suggestion that we as judges have some special knowledge or capacities beyond interpreting and applying the law is dangerously laughable. We are neither omniscient nor omnipotent. We are just judges who have been granted a very limited role in our republic. We have been bequeathed no special powers of discernment, insight, or prescience. Like the Wizard of Oz, we are mere mortals, and often frail ones at that. This is not about us. It is about something larger and more important, our liberties and our country. At the end of each term, my clerks and I visit Gettysburg. I like to do that to ward off the temptation for all of us to become callous or cynical about yet another year of making difficult decisions, as well as writing, joining, and dissenting from many consequential opinions. I want them to see that we have but a bit part in a much larger and more important undertaking, the preservation of liberty. I believe, as Lincoln so eloquently said, that the world will little note nor long remember what we say here. I want them to know that no matter how difficult the term, or how difficult the term was, and no matter how frustrated they might be after seeing how the proverbial sausage is made, they must remain optimistic and idealistic about our constitutional principles and the future of our country. Indeed, having spent a year at the court, I want them to be even more idealistic about our liberties and our Constitution. I have written that I am my grandfather's son. I am that indeed, and proudly so. But in a larger sense, I am also a son of the South and a deeply proud citizen of this great nation. I am at once the product of its ideals and its flaws, its contradictions. Once yearning for the liberties that our Constitution guarantees, now obligated by oath and vocation to protect and defend those self-same ideals, liberties, and principles. That is why I serve. As Lincoln said, "It is for us, the living, to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced." As we sit here tonight, a free people in a free country, I encourage you to rededicate yourselves to the principles of liberty that even in the breach guided our country and gave hope to this child of the South, that he too could enjoy the liberties about which Lincoln spoke. In this age, when it is fashionable to look for increased beneficence from our fellow citizens and those whom we think have more than we do, I ask you consider what any of us has done to deserve to live as a free people. Others have died, sacrificed, and left the lands of their birth for freedom, for liberty, for the life this country offers. But what have we done, each of us, to earn the benefits of their sacrifices? That is the question that I ask myself as I do my job and as I enjoy the fruits of their sacrifice and the new birth of freedom that Lincoln promised. I encourage you to resolve this night that none of them has sacrificed in vain, and that we all have the duty to preserve liberty for the next generation. Thank you all.